Welcome to Shielded, the podcast dedicated to helping Florida's first responders understand the laws that affect their work and their lives. We bring clear answers, practical tips, and stories to help you when you need it most. If you're a first responder in Florida, this is your playbook. Be sure to check out all of our resources at bicklerlaw.com. I'm your host, Paolo Longo, and I'm here with my partner, Jeff Bickler. At Bickler & Longo, this is what we do. Now let's get into it. Yeah. All right, everybody. Welcome back to Shielded, the podcast for first responders. I'm your host, Paolo Longo, along with my partners, Jeff Bickler and Vinny Luzzi. This is part 3 of our talk and our discussions around cancer in the fire service. As you'll remember, episode 1 was sort of background history, how we handled these cases. Part 2 was we got a statute, we got coverage, we got protections, we got a presumption, what that law gave, what benefits they got. And now in part 3 is the, I don't know, how do we call it? The be careful what you wish for because you just might get it episode.
That's
What's
actually
going
very
on?
good. That's actually great.
Right. Now that we've got this law, what the heck is going on? How do we fix it? Are there problems? First of all, what are the problems that we see? What are the practical implications of the statute that we have? And can anything be fixed? Pass off, Jeff.
Well,
go.
okay. That's quite a way to tee it all up, Paolo. I'll tell you. Since the law was passed, and even before it was passed, when it was in committee, and we were kind of looking at the proposed legislation, we recognized there were some issues, right? And those issues that we recognized initially, they've all come to be very problematic with a lot of these claims. And Vinny has been involved in actual litigation, deck action cases with respect to some of the problems. All right. So we can talk maybe a little more specifically about some of the cases that he's been involved with and the results. But, just from a brief overview, like number one, the diagnosis benefit. So let's say you're a retired firefighter and you fall in that 10-year window post-retirement that we talked about last time. If you didn't keep your group health insurance, that is an exclusion from coverage, right? And nobody could ever really explain to me what that was about and why is that necessary? Because, we know most of our clients when they retire, I mean, picking up that group health policy can be extremely expensive, and many times they let it go. And if they let it go and they don't retain that group health coverage, then arguably they're excluded. I mean, by virtue of the statutory language.
Right. A lot of these agencies are self-funded on the health insurance side too. So they make you keep the health insurance. They're paying the treatment anyway.
Right. So there's one. The other thing that we've run up against a lot, the death benefit is pretty clear in terms of, we think at least, in terms of what it provides, a $75,000 payment at death. But, the statute defines firefighter. Okay. So firefighter, under the statutory definition, is somebody who's still employed with an agency, right? And yet you've got sandwiched in there this 10-year window for retirees to collect benefits for diagnosis. But with regard to the death benefit, it doesn't say anything about, this window of potential recovery. So there's been an argument raised that if you're not still actively employed at the time you die from one of these cancers, there's no death benefit available.
Which is going to be just about everybody because the cancer doesn't come up when you're still working, and you certainly don't die as soon as you get it.
I mean, virtually almost every case that we've seen has involved a firefighter who has died a few years post-retirement. Now, there are exceptions. I spoke to one of the widows that we represented earlier last week, and her husband, they retained him in employment status all the way until he died. So that was unique. But, the vast majority of the cases that we've managed and that we've handled for widows and families, the person dies 2, 3, 5 years post-retirement. So, that's another real problem with the statute that is identifiable. There's been discussion in Tallahassee about trying to amend that particular provision with regard to this definition of firefighter. And the suggested solution is a 1-year window, which we think is just completely inadequate, and is not going to cover again, it's not going to cover anybody. So what's the point of, passing something like that? If you're serious about providing a death benefit and establishing, that this is a work-related condition, then you should pay that death benefit, at least something that mirrors the 10-year window for the diagnostic benefit, right? That
Yeah, of course, because I mean, 1 year. I mean, Vinny, what would that do to any of the cases that you're litigating? And if all of a sudden it had a 1 year provision on it, I mean, that would end every possible benefit.
I truly think that all of the death benefit cases we have maintained an action for, the death occurred beyond 1 year after retirement. So
Right.
it would essentially eliminate almost everything that we have gone through so far.
And
Right.
that's really, I think that's a really critical point, because we've been doing these death cases since 2019. And, we've been successful in nearly every instance in securing the death benefit, the $75,000 cancer death benefit for the widow or the family. So even though the statute says, you know, you have to be a firefighter as defined by the statute, which means you still have to be employed. Most of these agencies, once we get involved and we start pressing the issue, they will pay the claim, and they've paid the $75,000 benefit. So, it begs the question as to why you would concede that point without some court order that specifies, oh, there's no coverage if you're not employed as a firefighter.
Or why you'd go out of your way to advocate to amend the statute from a non-time to 1 year.
Right, right. Exactly. I mean, our interpretation of the statute is that, look, it's not intended to require the person to remain a firefighter. If you read the statute in its entirety and to make sense of it, the death benefit has to be available, right, to the widow more than a year or, employment as a firefighter. So that's how we've read the statute. We don't have a decision out of the circuit court yet. We do have at least one deck action pending on this very issue. That's the Geld case, Geld versus City of Melbourne, that Megan is actually litigating. And interestingly, the City of Melbourne in that case, they're like, look, we're not sure how to read the statute either. So they sought direction from the Attorney General's office. And they asked them to intervene, and they refused to get involved. But, we're at a point now where we're gonna stipulate to the facts and just ask for a judicial interpretation of the statute and whether or not that benefit should be paid. So, and not to get too deep in the weeds on that, Paolo, I know, we have limited time here, but, that's another obvious problem with the statute. I could go on. I mean, there is no enforcement mechanism in this statute.
Yeah, we'll get to that in a minute, because that I think is important, because this statute was certainly not drafted in the way that you or I had anticipated or intended it to be drafted at all. What passed was, like it went through a blender, and then what the nonsense that we got out of it is just complete, what.
Well, look, I mean, we had no role in passage of that legislation. I mean, let's just be clear about that, right?
Right,
I mean,
right.
they don't listen to us in Tallahassee, and I think we're just lawyers enforcing the rights of firefighters, right? Um, I it would be preferable for sure if we could have some input because, we do this work on the ground, but that doesn't seem to be how things work up there. And, we're sort of left with, okay, if this is what passes, then, what's the avenue of recovery for our clients? Well, yeah, the enforcement mechanism and the fact that there's no recovery of costs or attorney's fees related to these claims. So, if you want a self-executing statute, you've got to account for attorney's fees. And they don't do that.
Well, and you've got to tell us where to file the claim, right? Because I mean, I filed these claims in circuit court when this stuff first came out, and the circuit court says, "No, this is work related. It's workers' comp. Go to workers' comp court." Then you file a claim in workers' comp court, and the workers' comp judge says, "Well, this is an alternate benefit outside of workers' comp chapter 440. So go to circuit court." So you got frickin' frack pointing,
Yeah.
their fingers at each other, right? And then, and so Vinny, you're knee deep, neck deep, probably eyeball deep in a lot of these cases. I mean, as a practical matter, when you're in front of a judge, whatever the hell court you can get into, right? What are the kind of things that obstacles that you're running into?
Yeah. So I'd say once we kind of kept getting the boot from workers' comp, after the initial boot from civil court, we just started filing everything in civil court. And so we file our deck action, we go to civil court, and we run into these defenses, pretty much all of which Jeff has mentioned. The definition of firefighter, the timeliness of keeping your health insurance, whatever the case may be. We've also run into the initial diagnosis language in the statute. So, for example, a firefighter, if they meet that criteria that we went over in the first couple episodes, they get that $25,000 death benefit plus the health insurance, the copays, and stuff like that upon diagnosis. What it doesn't say is, okay, well, what if you're diagnosed with, two forms of the cancers that are listed? Or what if you have a re-diagnosis of the same cancer that you had 4 years ago? So we've run into arguments where they are saying this is a one and done thing. Doesn't matter what type of cancer you have. Doesn't matter if it comes back. We're only giving you $25,000 and this, reimbursement of copays. And so that is kind of what we're seeing more so now. I think the firefighter definition defense in litigation has kind of slowed down based on some of our positive outcomes that we've had. And I think that's a good thing. But obviously, if there are changes with the 1 year window post death, I think we're going to run into a lot more litigation.
Well, and that's an irony there, isn't it? I mean, Vinny, and that's really the truth. I mean, we saw those defenses raised with regard to the definitional issue early on, but less so in the last few years. And they don't seem to be fighting on that basis. And I'm not saying they don't have an argument there, right? But the reality on the ground is that we've been seeing those claims being paid, and where we have to file a deck action if that's necessary, and they roll over and pay it. Well, so be it. I mean, it's a $75,000 benefit, if not a $225,000 benefit, depending on how you read the statute, right?
Right. Well, and so, notwithstanding the deficiencies in the law, right? But we've had some success, and so it's not all doom and gloom, right, guys? I mean, we've
Oh,
had
no.
we've had some good recoveries, and we've had some good successes. The problem that I foresee coming is that if the legislature tries to tinker with this, they're just going to make it worse than it already is, right? I mean, that's the fear.
Yeah.
Which I couldn't imagine how that would possibly happen, but apparently,
Well, a 1 year cap is absolutely, I think, in my estimation, making the law a lot worse than it is. And, the unintended consequence there too is that it eliminates this other argument that we're making in a lot of these cases, that there's an automatic entitlement to workers' comp death benefits, right? So if it were limited to that 1 year post-retirement, then you couldn't make that argument about the automatic entitlement for somebody that died 3, 4, 5 years out of the service, right? Right now, we can make that argument. We don't know how the court is going to rule on that.
right, because they just tried a case on that
Vinny
issue,
just
right?
tried a very important case, the first one that we've actually taken to trial on, an occupational disease theory with all, the bells and whistles and all the experts lined up. Yeah, I mean, Vinny, you want to talk about that a little bit? I think that's such an important case.
Yeah, no, absolutely. So we have this firefighter who was originally diagnosed while he was employed with the municipality that he worked for, and so the city gave him benefits under 112.1816, which was the $25,000 benefit and the reimbursement of copays and all that. They acknowledged that. They ultimately granted him an in-line of duty disability pension for his cancer about a year after his diagnosis when he couldn't go back to work anymore. And ultimately, this firefighter passed away from his cancer just 2 years after that pension was granted. And so the widow came to us, and we successfully got her the $75,000 death benefit under 112.1816, the cancer law, which again is recognizing that her husband's cancer was work related. So I like to point that out, that so far in this timeline, 3 times the city has recognized the cancer as work related. And so, kind of leading into what Jeff said about automatic entitlement, we filed a claim in the workers' comp court requesting death benefits based on a work-related injury for this widow. Now, workers' comp has the $150,000 death benefit, which we believe is in addition to the $75,000 death benefit under this cancer bill. And so we made, I think, 8 different arguments. It was an all-day trial. It was an all-day thing. And it was a big case. We had epidemiologists involved. We had specialized physicians involved. They had an oncologist involved. We had the chief of the fire department. We had the state fire marshal involved. It was a lot of testimony from very important people. And so ultimately, we made the argument that, look, they are what's called judicial estoppel and equitable estoppel, essentially, number one. We said that this city cannot say 3 different times that this firefighter had a work-related cancer, but now all of a sudden, because they just don't want to, say it's work-related for the workers' comp procedure. But we said, look, you can't, go back and make these inconsistent statements. That was kind of number one. Number two, we said automatic entitlement. The way you read the cancer bill, it says that these benefits are in addition to any other available benefit. When you
including workers' comp.
Yeah, when you read in addition, what are you thinking? Okay, well, the only other benefit out there is workers' comp. So that's got to be the only other benefit that's in addition to this benefit that we just got. That was number two. I guess that's number three because the estoppels were kind of together. But we also talked about a kind of specialized evidentiary standard for firefighters under an occupational disease claim to workers' comp. So occupational disease and workers' comp is a near impossible burden, put it that way, to prove that an employee was exposed to specific levels of substances that can cause a specific type of disease, that you need epidemiological evidence to demonstrate that. And then apparently it's telling you need also specific readings about specific levels to support your case.
Yeah,
and
precise measurements, right?
Right. And so when you're talking about cancer and you're talking about cumulative exposure, which is what the cancer bill is, which is what everything that we're talking about is, you can't go back 25 years ago and say, oh, well, this much PFA came from this brush fire in, August of 2001. It doesn't work like that. And so what epidemiology has done across the nation and overseas, and you got Canada, Spain, there's studies everywhere. They have said, look, we know that there are at least 24 substances that come from the firefighter environment, whether that be fires, whether that be the hazmat gear, whether that be the diesel exhaust, benzene, formaldehyde, whatever, what's listed. We know that these are present constantly for a firefighter to have exposure to. And because of that, now we're going to study the rates that these firefighters develop cancer for. And so they took this research, and ultimately our firefighter had colon cancer, and it was determined that the firefighter has a 1936% increased risk of colon cancer because of their exposure to these substances. And so we took our expert epidemiologist, we had her explain pretty much all of that in a much more detailed, much more scientific approach than what I just did. To say, like, look,
You did great.
This firefighter for 23 years was exposed every time he was on shift, because exposure is 24 hours every time you're on shift. It's not, doesn't turn off and off. And so you have 23 years of exposure to 24 specific substances that are known to cause cancer in humans. And this person ultimately developed cancer and died from it. And so we presented this evidence. Obviously this just took place last week. We don't have a ruling yet from the judge, but I think it was a very important case one way or the other, because there's no other way we could have proved that case. And if it's an impossible statute to prove, then why does it exist? And
well, then that raises, right. It raises all the constitutional concerns that we talked about and we raised to some degree with the judge of compensation claims, right? You can't have an exclusive remedy for a disease of this kind under, the Florida Workers' Comp Act and not provide an avenue of recovery for that. You can't cloak an employer in immunity from suit and then make the burden impossible to prove a case.
And especially when they admit 3 times that it's work related.
Thank you. Right. And I think, this has been a labor of love for the firm. Obviously we have poured our time and energy and resources into this. this case and also this idea, because, it's been a passion of mine since, gosh, at least 15 years ago, that we really need to establish this as an occupational disease in Florida, right? If we have to do it the old-fashioned way, utilizing what the statutory requirements are, then by God, we're going to do it. And, I think that Vinny created a record here that, if we don't prevail at trial, I think we've got a reasonable chance of success with the appellate court.
Right. It's just illustrative and it really highlights the problems with the current iteration of this statute, right? Which, it on paper, it's a feel good bill, right? The folks in Tallahassee can pat themselves on the back and say, we care about firefighters and we're going to provide this benefit. But for the people on on the ground, right? For the people that are fighting these cases, which is pretty much us and the victims of this disease that study after study after study is continuously showing, to cause this problem. I mean, it's a real hollow victory to have a statute like this.
Well, and that part of that, Paolo, is because they insisted on doing this alternative to workers' comp. If you just had created a straight presumption like the Hart bill,
Right.
and it operated in Chapter 440, we wouldn't be dealing with most of these issues, right? But it's the weirdest thing because yes, it's work related, but no, it's not work comp, right? I mean, think of the lunacy of
Right. You can't have your cake and eat it too, right? I mean, there's some risk
well,
manager special going on there or something, right? I mean, it's just well, and that again, that just begs the question to the constitutionality of the problem. I mean, you can't have a right taken away and then not have a remedy and not even be told, given a proper forum and a mechanism of enforcement anyway.
I not to harp on that too much, but I think it's a really important point, and it's something that so the IFF medical director, Dr. Danny Wu, testified in the case. And really what he was saying was the agencies, if they're not doing a good enough job of creating a safe work environment, it's a negligence issue, right? Now, you can't bring a negligence case against, a fire service agency if they're cloaked in workers' comp immunity. So it really does highlight this problem. And
Well, maybe if it's an alternative benefit and it's not workers' comp, then we'll go straight negligence next time.
well, listen, I gave that a lot of thought, honestly, but you got to go through the process first, right?
Right. And you get the sovereign immunity issues too and
Then you've
everything
got
like that.
sovereign immunity caps and all the rest of the stuff. So yeah, I mean, I have every hope that we're going to prevail in this case because I think Vinny just did such a great job of creating a record and presenting the case. Um, but we'll do what we need to do to keep fighting. The problems just persist. I talked to an Orlando firefighter and his wife just earlier. I guess it was last week now that was diagnosed with a terminal glioblastoma. And I mean, this case, it's like a law school exam. He worked for Orlando for 25 years, retires. He takes a job with Lake County. He had cancer, skin cancer, while he was at the city of Orlando. He put in for the benefit. They paid the 25,000. Right. He takes the job with the new agency, and then he's diagnosed with the glioblastoma after about 3-4 months there. And so now he wants to make the claim against the city for the glioblastoma. Guess what? You don't
Yeah.
work for us anymore. And that's an exclusion under the statute because he took a job with another fire service agency.
Right.
It's an absolute exclusion. He took a job with a new fire service agency. He can't even make a claim against his current employer, right? So, and now we're going to talk, okay, what about the workers' comp benefit? Because this is going to be a death case, right? And where are you going to file that? You're going to, okay, last injurious exposure. I guess we're going to go against Lake County, or do we try to bring Orlando into this? And then
Well, gonna have all kinds of statute of limitations problems and,
oh, yeah.
it's that's worse than a law school exam. It's
Well,
terrible.
and then get this. So here's another problem with the current cancer statute. Is that $25,000 taxable? Well,
Well, according to some employers,
the city of Orlando not only said it was taxable, they took the taxes out of the payment on the skin
unbelievable.
cancer claim, right?
They
But
withheld it like a paycheck?
yeah, yeah. So and then they won't pay. They're not willing to pay the out-of-pocket expenses, which we run into all the time. Where you got to beg, borrow, and steal to try to get them to reimburse for out-of-pocket expenses. And again, it's just this idea that somehow there's a better alternative to workers' comp. It just doesn't really work in the real world. That's what we're seeing. Um, and I think I said this last time. If they were concerned about choice of medical care, fine, give us a presumption and allow choice of medical. Right? It's not that hard to do legislatively.
Right.
But
Right.
anyway, I could get on my soapbox and rant about
Well, that's
that.
what we're here for, man.
Yeah.
I mean, preach on, preacher, because that's the whole point of this, right? Is to get, people involved and people listening to this stuff and hearing about these things, because quite frankly, a lot of these men and women wearing bunker gear every third day are not getting this information, and they don't know what's going on in Tallahassee.
Oh, they have no idea. No.
And so, if we can help anybody, then, it's worth it. So, that's the whole point. This
Well,
is the
I mean, I'll tell you, go one step further, Paolo. I mean, when it was highlighted, I guess the FPF had their legislative workshop, before the session. And I think it was in November this year. And, there was discussion there was going to be, movement on the cancer bill and try to, a positive amendment to the cancer bill. But it was never shared with any of the leadership there, as far as I know. And I talked to a few people about what that proposal was going to look like. And so the proposed amendment eliminates the requirement that you retain your group health insurance, but it also puts this 1-year cap on death benefits.
Yeah, and when nobody knows about it.
And nobody knew about it until they showed up to walk the halls, you know. And of course, I was paying attention to it because this is what we do, and I saw it, so I started raising, some objections with the people that we work with, and some of the leadership that will listen to what we have to say on these points. And it's already moved through the Senate. I think it's passed through the Senate. I don't know where it stands in the House, but
Right. Well, and just as a disclaimer, right, while we're actually recording this, the House is or the legislature is still in session. By the time it airs,
right,
the legislative session's likely going to be over. So
yeah, and we may have a new,
the coin is in the air.
Yeah,
the coin is in the air. We don't know if it's going to be heads or tails. I mean, hopefully this legislation will fall off the rails in the next couple of weeks before the session ends. Because if not, there's going to be some real upset firefighters and some real upset widows, because there's not going to be much we can do for them.
No, I agree. I agree.
It's rough. And I mean, I think, like you said, this isn't, there is an easy way to fix this, right?
Yeah.
Establish a presumption, just like the heart bill. I mean, we could go on, but I mean, it's not a difficult thing to fix.
Well, Paolo, you could even clean up the cancer bill if you really were serious about doing it. Give an enforcement mechanism, provide for, recovery of litigation costs and attorney's fees. You want to make it self-executing, right? I mean, just add former firefighter to the death provision, rather than get all tied in knots about the definition of firefighter, right? I mean, there are simple fixes that could be initiated, short of just a straight presumption. But again, I think that requires the engagement of somebody who's actually doing the litigation and handling these cases to provide some guidance to the legislature in Tallahassee.
Right. Let's send Vinny to Tallahassee and tell him, he's trying these cases. This is the reality of what's going on. We'll get a bus full of widows up there.
Hey, we've done it before. We did it with the PTSD stuff. So,
you get a bus full of widows up walking around Tallahassee, talking about, if you pass this bill, none of our, husbands' claims would have been paid. They're leaving behind families, and you got agencies squabbling over $75,000. I mean, it's unbelievable.
Which, I mean, again, the fiscal impact of this bill is negligible. I mean, it's a rounding error. So there's no real arguments here, as far as I'm concerned, about not doing the right thing and just making these benefits more available to people.
Well, especially in the cases like Vinny's, where you've got line of duty disability being accepted, right? So the employer has to do that. I mean, that's an affirmative action, right? I mean, I've handled enough disability claims where the employer has to check a box.
You got to sign off on it. Yeah.
And they got to sign off on it. So I mean, you've got the employer saying, yes, this is work related. Okay. Then you've got, 2 or 3 other times where, the benefits are being provided under a different provision of the statute. And then all of a sudden you get to the death claim and, all hell breaks loose.
Yeah. Not work related now.
Well,
I mean,
but part of
how
that
do they do
process,
that?
part of that, Paolo, is this is an adversarial process, and you've got defense attorneys that are sitting on the other side of this billing like there's no tomorrow
Right.
to
Well, I
deny
mean,
these claims and to get paid.
there's your fiscal impact
Yeah. Well, thank you.
because because the defense bill is bigger than the payout.
Yep. In many cases, that's true.
Right. I mean, Vinny, in your case, I mean,
Huh.
the value of the benefit that you were seeking, it pales in comparison probably to, the bill that the
Defense
municipality
costs.
got for fighting the case.
Yeah, you're talking 7,000 pages of medical records, 15 to 20 depositions. I mean, then an all-day trial, that prep. Yeah.
It's unreal. It's unreal. Well, I mean, I guess in conclusion, wh- what's the future? What's the future look like? What are we going to
The
do?
future is
What
we
are
fight like hell. We keep fighting. We keep fighting. Because really, and that's kind of the point of the Kateb case, that Vinny did such a great job on. Win, lose, or draw, right? We die on that hill because that's what we're called to do. And if we lose that case and we take it up on appeal and we get a, appellate decision, we can go to the legislature then, right? And we can try to change the law that way. And we do everything we can as lawyers to advocate positions for our clients,
right?
but at the end of the day, if the things don't break our way and we can't win given the current state of the law, then the law needs to change, right? So that's how I look at it.
Yep. I mean, I think that sums it up. Vinny, what do you think?
Yep.
I think that's it.
All right. Well, that's a wrap.
Well, that's a wrap, guys. So anyway, I thank you for your time. Great job. And any of our listeners, if any of this helps in any bit, or anybody that can benefit from this kind of information, at Bickler Law, you can reach us anytime. We're always around taking calls. We're happy to help in any way. But until next time, we'll see you soon. Stay safe. Thanks for all you do.
Thanks, guys. Appreciate it.
Thanks for listening to Shielded. At Bickler & Longo, this is what we do. We've represented thousands of first responders across the state of Florida. If you need assistance, don't wait. Please reach out. To learn more, head over to bicklerlaw.com or email us at info@bicklerlaw.com. You can also follow us on Facebook and Instagram at Bickler Law. And if you found today's episode to be helpful, please share it with a fellow first responder who might need to hear it. Until next time, stay safe and thank you for all you do.